Assalamualaikum warahmatullahi wabarakatuh. My name is Zulfa binti Zulkifli. So first, let us understand what is ADR. Okay, ADR is a short form that stands for Alternative Dispute Resolution. It is a way to solve problem without resorting to court service. Technically, ADR refers to the effort in achieving a goal in resolving a dispute other than through the court, or simply a dispute that resolved out of a court using an intermediary. ADR was discovered by Roscoe Pound in 1912. The discovery have been found because of court that always have an issue such as overburden, trial delay, excessive price, a shortage of lawyer, and an entire substantive legislation outdated. Moreover, Pound also noted that there are a difference in the use and acceptance of legislation between the rich and the poor. This is because of a string of legal practice that often dominated by the wealthy for their own benefit. So next, let we see the objective of the existence of ADR. As we said earlier, ADR refers to the effort in achieving a goal in resolving a dispute other than through the court, where it is an easier and faster dispute mechanism. Okay, the basic objective of ADR existence is first, affordable and speedy trial with less procedural work. Okay, this is because ADR can be proceed when all the parties reach a certain agreement and meet all the requirements that need. Hence, they does not need to wait for exactly date like the court system. Also, this method is far more cheap than using court because it does not involve too much people and procedure. Okay, the second objective is ADR is aimed to settle the disagreement peacefully by way of compromise negotiation of fair settlement. The existence of ADR is to achieve a mutual agreement where it can be solved the problem between two parties. This method usually use third party who will act as a judge that will put the best solution by negotiate with all parties for the problem controlled by him. And lastly, ADR is used as a direct approach to settle the dispute. It can be said as one-to-one conversation and rigorous discussion to give a better understanding of each party's view. So next, let us see the view or opinion from four mazhab. First, according to the Hanafi school, the alternative dispute resolution is an agreement in which the parties concerned prefer a more open mutual agreement in reaching in the agreement. It also includes the appointment of an arbitrator to act as a representative of the parties involved, which a result a decision achieved through arbitration has less authority than a court verdict. However, based on Maliki, any of the parties involved can designate an arbitrator, and the nomination of an arbitrator cannot stop the procedure once they have begun. And next, according to the Shafi'i sect, attribution proceedings are distinct from judicial proceeding. This is because before issuing a valid arbitration ruling, an arbitrator is allowed to alter their mind. And the last is from the Hanbali sect. The output to alternative dispute resolution method and the court proceeding process does not have much difference, as arbitration rule have the same effect as the court proceeding process. Therefore, an arbitrator must have the same qualification as a judge, or in simply word, the arbitrator must be on par with the judge in recognizing and handling a case. This is because any decision made by him will involve and affect all parties involved.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nabila binti Taji'i and I'm going to present my part, which is about ADR in Islamic finance. Alright, so ADR, or alternative dispute resolution, is actually a way of resolving conflicts between parties that is not a court procedures. So the objective of ADR or alternative dispute resolution is to settle a disagreement between parties seeking justice. It is for who has experienced an injury or loss and want to make a claim for any damage or losses they have obtained, so they can use ADR. ADR is actually a fast approach to settle a dispute based on the parties' rights to choose their own laws and processes. Alright, let's see the processes of ADR in Islamic finance. ADR strategies used to resolve Islamic finance problems by the process on the following. Firstly, we can see it is stated here is nasihah or counseling, and then suluh or mediation or conciliation, and thirdly is tahkim or arbitration, and fourthly is court or adjudication, and actually more than that. So all these processes in Islamic law are intended for various forms of dispute, and some are relevant at various phases of a dispute. Alright, so now I'm going to explain about all of those processes one by one. Let's start with nasihah or counseling. It is a process that designed to provide mediation between disputing parties. So the process of nasihah is actually the habit of giving truthful advice, which is so important in the Muslim society that has to follow certain rules, including it should not be given in a way that implies accusing any of the disputing parties. And also, before performing a nasihah, the advisor should set a good example for others to follow. So, community leaders, imams, Muslim counselors, and social workers can give nasihah on how to prevent in potential financial transaction problems. Okay, so the second one is suluh or mediation. Suluh or mediation is a process when an individual parties agree to settle a disagreement among themselves without the intervention of a third party in the process. So from a legal standpoint, suluh is a contract over which there is a disagreement. Okay, so the third one is tahkim. Tahkim is defined in Sharia as when the two parties choosing a judge to resolve their dispute and their claim. So the party themselves can select the arbitrator, and the party also must accept the decision made by the arbitrator. Okay, so if the process is used properly, it will provide an opportunity to give the parties in dispute guidance, as well as to facilitate problem solving between them. And lastly, we see court and adjudication. So court or adjudication is the process by which a judge settles a disagreement between two or more disputing parties based on Al-Quran and Sunnah. Court is actually an Arabic word that signifies judgment. So actually in Muslim societies, there has always been a greater focus on the Islamic judicial institution of the court, or we call it as qadi, as well as the function of the judge, or qadi we call it. So it is because of the decision that they have made is permanent. Alright, so that's all the given ADR processes here. Aside from the ADR processes outlined above, there are more processes that can be utilized to resolve conflicts between transacting parties. Some of them are Mad'ab, Muhtasib, Fatwa of Mufti, and more. So that's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nabila Buti Shahbuddin, metric number 2019-230402. Okay, I will explain about the institution and issue or challenges in alternative dispute resolution. So the institution that obtain in alternative dispute resolution, first is Kuala Lumpur Regional Arbitration Centre, and then the second is Financial Intermediation Bureau. So move on to the issue and challenges in alternative dispute resolution. So as we all know, alternative dispute resolution ADR is a simpler and more accurate mechanism that takes place outside the court. Courts are a solution to a problem that is often used by consumers who face problems and dispute. The community will be judged transparently and fairly following the law set by the court institutions in Malaysia. But the court system also has its weaknesses and advantages in the scope of Islamic finance and banking in particular. So the issue that can be resolved in this situation is the lack of judges in resolving cases related to Islamic banking and muamalat. The Malaysian Judicial Department has already taken the initiative in the appointment of special judges for relevant case studies. But today, the development of the Islamic financial sector is accelerating, involving various sectors of Islamic banking, takaful, Islamic capital market. This causes the judge who manage the case cannot resolve the case immediately, and even the number of cases is increasing rapidly that have been registered in the Muamalat Court from year to year. So this problem can be solved by training the judges in a good understanding of Islamic law and giving in-depth exposure to deal with financial cases related to Islamic banking. This can provide preparation for judges if appointed as special judges in the Muamalat Court, and at the same time can add judges who will resolve Islamic banking cases easily and quickly. As we know, the establishment of Muamalat Court was only established in Kuala Lumpur High Court, which is KLRCA. And here we can see that people from other states who have case studies in Islamic banking find it difficult to voice their problems because there are too many cases at the same time. So therefore, Muamalat Court should be established in each state to handle cases in those states related to Islamic banking. So in addition, the creation of alternative dispute resolution ADR is due to the weakness of the court, where the high cost of expenses and the negligence of the court causes the weakness of the court institution. So based on Nur Husnah Omar and Ruzian Malcolm, according to his analysis based on Gashnam Singh lecture, which issued factors that will weaken the court that can happen in common law countries, such as high cost, lack of awareness of general knowledge of the law and legal language in English. So it can make difficult for local to understand. So another weakness that we can see is the application of alternative dispute resolution. So the various types have been described, among which is arbitration. This arbitration mechanism is one of the efficient solutions in resolving Islamic banking dispute. This method does not have to rely on court-ordered legal proceedings that take a long time to resolve. At the same time, it can save time and can be done in secret between them. And no party will win or lose in resolving a case well. And there are also problems encountered in this mechanism, where arbitration at the Kuala Lumpur Regional Arbitration Centre (KLRCA) is international, where the cases handled are B2B cases. Among them are commercial transaction, vendor-supplier relationship, professional services, and so on. So it can be concluded from the use of this arbitration mechanism that the moderate class can find a great expert in the arbitration to resolve more specific related cases, as well as get reasonable costs compared to KLRCA, which is international institution. So next, the mediation mechanism is also one of the good solutions to refer to the problems they face. The efficient mechanism is resolving issues related to Islamic banking. The mediation mechanism adopts the nature of discussing first, so it's not inherent to bring the cases directly to the court, which will take a long time. This mechanism also offers a low cost and efficiency in being an alternative dispute resolution for Islamic financial cases. However, each matter has its weaknesses where the two parties who will dispute must agree to the mediation service that has been set. If one of the disputing parties does not agree to the condition laid down in the mediation service, then this mechanism cannot be applied. So, both parties need to agree with mediator resolving their cases to resolve the issue properly using this mediation mechanism. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Ashikin binti Cik Mat, matric number 2019294694. So, I will represent the conclusion and for suggestion. Based on research, we find that the ADR has shown positive development in this matter, and it more convenient than settlement through court when dealing with Islamic financial affairs in future. Basically, in solving all dispute related to Islamic finance in Malaysia can be solved in two ways, either through court proceedings or through ADR. The ADR method is an alternative problem solving without a court trial, and it can be used as a major method in the future to resolve problems and dispute in Islamic finance. Okay, we continue for the slide. In these studies, we know that the method used by ADR, which is arbitration dispute resolution methods involving disputants who present their case before an independent tribunal that is impartial, which is fair, and must be a person who is an expert and has legal knowledge. Basically, the third party will check the facts in the case by making an assessment before deciding. In contrast to the mediation method, which is a process in which a third party will be neutral party for the parties involved in the dispute to reach an agreed solution to their conflicts. Usually, dispute related to Islamic finance transaction resolved in court will refer to experts such as the Sharia Advisory Council, which is SAC for Bank Negara Malaysia. There are also findings on 7 criteria that can be explained as a key elements of ADR that can be used by Sharia experts in resolving certain disputes. These elements are taken based on the source state in Quran and Sunnah, which is if these main elements are found, can facilitate and further speed up the mediation process. Among the key elements is mutual rights and responsibilities, reciprocal relationship between parties, conflicts, advice and consultation, human rights, and bargain and compromise. In mediation or sulh, get more attention from the parties because of the strength of the process and its viability to resolve disputes in Islamic finance. This process can be identified through the production of cost-effective against the disputing party, because the disputing party does not need to appoint a Sharia lawyer to represent them in court later, and this matter of course costs a lot by appointing a lawyer. This method, the sulh does not require the presence of a lawyer, besides saving time and money. The need of reaching a solution should also be voluntary without any coercion, and it should be in a win-win situation with the expectation that the agreement reached can maintain respect and relationship between the disputing parties. This method adopts flexible procedures, creative expertise in a particular field, where the parties involved can participate directly in reaching a joint solution. This advantage will not exist when making a settlement in court. This is because dispute and settlement argument are done through lawyers, and the decision determined by the judge will only be in favor of one of the parties. There are several useful channels create user to refer with a problem accounted for, which is Bureau Financial Mediation and Malaysian Mediation Centre, which is MMC. It can say that this medium is more referenced by customers in view of it is more geared towards financial issues. This medium is competent in resolving Islamic financial and banking disputes, and its strength can be seen in this mechanism is that it is negotiable in nature without having to rush to bring the case to court. In addition to offering low cost, this mechanism is also competent in terms of the eligibility of the intermediary. Looking at this, it clearly shows that mediation mechanism, in particular the Financial Mediation Bureau, are appropriate and competent in being an alternative dispute resolution for Islamic finance and banking case. However, the two disputing parties must agree to obtain this mediation service before it is used. If one of the disputing parties disagrees, this mechanism cannot be used. Through method of dispute resolution discussed above, it can be seen that ADR has some drawbacks. However, it is appropriate in resolving disputes Islamic finance and banking. The nature of ADR is fast, maintains confidentiality, and discussed, highlighting the suitability of this mechanism in handling cases. Disputes are not only Islamic financial and banking disputes, but also dispute another case.